And we continue our focus on the court stories this week. We're now joined by Elton Hart from the University of Johannesburg's Law Clinic to unpack the developments in the country's courts this past week. Well, a very good afternoon to you, Mr. Hart. Thank you so much for joining us. Welcome to SA Today.
Good afternoon and good afternoon to the viewers.
Now, Home Affairs Minister Dr. Aaron Motsoaledi has been joined as a respondent in Dr. Nandipha Magudumana's challenge to what she says was her abduction by South African police in Tanzania, which means that he'll be able to submit evidence about what he insists was a lawful deportation. Would the minister's testimony play a significant role in the determination of whether Dr. Magudumana was abducted or not?
For me, I think the Department of Home Affairs insisting on being added to the proceedings, I don't think that they were needed because on their own version in the media, the minister said that the Department of Home Affairs is not there to arrest and detain people. They deal with people flouting immigration laws, citizenship, and those type of applications. They don't arrest. That's the jurisdiction and mandate of SABC. So for them to be joined now, because Magudumane is alleging that she was unlawfully arrested and detained, which the Minister of Home Affairs said that's not their mandate. So, and she's not saying that it's Home Affairs, that she said SABC. So for me, the issue needs to be ventilated between SABC and then her subsequent detention. It will be now the Department of Correctional Services as well as the magistrate that actually issued the J7 warrant for her further detention. So I think what the minister is going to say is most probably like coming with evidence or what he was trying to hide behind prior to come and say now, okay, there's information that sits with the Tanzanian government. He's just going to open himself up that he must now give the information, and that's why I see. But for me, Magudumana, in her paper, she was right not citing them in the first place.
All right. And the fact that Dr. Magudumana suspended her bail application in the Bloemfontein Magistrates Court, how likely will this disadvantage her bid in the High Court to be discharged?
I hear a lot of people saying that people say that her application lacks urgency because she abandoned her opportunity to ask for bail. But my view on this is that if she subjected herself to the bail proceedings, she would then undoubtedly on her in that version or by partaking in the bail proceedings say whatever is happening in this Bloemfontein Magistrates Court is lawful. So for me, I think there was a clever ploy by her to say, I'm abandoning my bail. I'm not going to partake in bail proceedings because my view is whatever is happening here is illegal, unlawful, and I will not partake in any unlawful activity because that could lead to a tacit waiver of your rights in terms of the Constitution, which is your liberties, freedom of movement, expression, and those type of things. So I think it was a clever ploy by her not to partake in the bail proceedings. That would then also, and obviously urgency is there because her liberties is taken away. Doesn't matter how small or how big a person is, if your liberties, you are incarcerated for an illegal reason, then it becomes urgent for you to be released.
You know, Mr. Hart, I suppose this conversation now thrusts into sharp focus the argument that someone's right to freedom, has been trampled upon, therefore warranting to be released on an urgent basis, as averred by Dr. Magudumana. Is this argument robust enough?
I think it's robust enough because it speaks to the Constitution, subject to like your liberties, your physical liberties and things that's entrenched in the Constitution is just one of the rights that just is like a little less than the right to life. The right to life is non-derogable, is the most important right. And then these rights, to your freedom, your movement, your liberties is somewhere just a little bit below, which is a very important right. And it cannot just be easily trampled upon. And we can't even speak about that the limitation clause can kick in because we say whatever they did was or she said whatever they did is unlawful. And hence, we can't even invoke Section 36 of the Constitution to say, yes, there is a right. Yes, we can limit it under certain circumstances. Yeah, it's just something wrongful, illegal that has happened according to Magudumana. And that's why that right kicks in and for me, I think there is a case that she has made out and there's a case for the 3 ministries that sent a plane from South Africa to go and collect her and bring her back. Because that's not how deportation works in my mind, in my book as well.
All right, let's take a look at other court matters. We've seen President Cyril Ramaphosa wanting to declare the summons issued by former President Jacob Zuma as unlawful, unconstitutional, invalid. He now argues that Zuma's bid for a private prosecution is constitutionally flawed. I want us to focus on what some of these flaws are and whether they are robust enough for the court to throw this case out.
For me, looking at that case, I think what the former President Zuma is doing now is like it borders now on maybe saying this is a frivolous type of application, because he's saying that he wants to charge the current sitting president with accessory after the fact. I mean, the NPA, most probably through Billy Downer and then Karen Mon, publishing his information. I think he's got something to go after them for making his personal information that is confidential available public and how it was made public. If you use the court process and there's a court order, then you can do it. But I don't think that the application that the president is currently bringing to say that I want to also charge the current president for an accessory after the fact holds any water. I think that application, the court will just frown upon it and most probably dismiss it with cost. That's my view on it, what I've seen. I don't think there's a strong case for the former president to come against the current president to say that he must be added. You need to show that the current president has committed or omitted to act in terms of a statute, and there's no statutory duty really on him to protect the right of every individual in the country. Yes, he's the president of the country, upholds the constitution, but we cannot now expect. So if I come tomorrow and say, but my dog has been stolen, you must now make sure that the police now follow up on this case. That is not reasonable. That you can expect the president is the same that the former, although it's a former president. There's procedures. Go file a complaint at the police station and let a docket be opened, and then bring it to court, and then let them be criminally charged if they have violated a right or a statute in this country.
All right, Mr. Elton Hart from the University of Johannesburg Law Clinic.